Good afternoon, everyone. I'm James Pittman, co-founder at DocketWise, and this is the Investor Visa EB-5 webinar. And I have with me Michael Harris, and Michael is an immigration attorney located in Florida, who devotes a significant amount of his practice to investor visas. So I'm going to introduce Michael, and then we're going to have a conversation about the EB-5 Investor Visa Program. What is it? How did it come about? What are some of the recent changes that have been going on in it? What do you have to think about as a practitioner if you're planning to get into this area and succeed in it? So without further ado, I give you Michael Harris. Michael, tell us about yourself, your background, and how you got into the EB-5 area, and what's your practice like overall?
Hi, James. Thanks for having me here. I'm happy to present with you guys. So I've been practicing law for just over 15 years now. I've worked in the field of immigration law for over 22 years. So I've been involved for quite a while, mostly with these days with business and investment-based immigration, including, I guess that includes employment-based immigration. So all sides of that. I'm also I'm a board certified specialist here in by the Florida Bar. Certified as an expert in immigration law since 2013 now, and pretty much most of my practice, as I said, involves those areas. But as a specialist, I don't shy away from many different areas of law, of the immigration law. So I'll handle some family immigration and some other complex problems with inadmissibility, clients and so on. I've been involved in the EB-5 program my entire time practicing law, and have grown into the field like some other lawyers have. Initially, my work involved mostly the work of project work for EB-5 projects that wish to be raising capital under the EB-5 Regional Center program, and have represented companies that myself and others, other team members have been able to get those companies designated as regional centers around the country. Today, I represent investors as well as regional centers, or projects that are affiliated and sponsored by regional centers, as well as other direct standalone projects now. A lot of this has changed now with the new EB-5 law, the EB-5 Reform and Integrity Act that was enacted in March. What we could do in the past is quite different. So in the past, I would be involved in a variety of different pooled investment projects for EB-5 investors that were not affiliated with the Regional Center program, but that now is no longer allowed.
Mm-hmm. Well, that's an interesting point, Michael, that as an attorney, you can really represent both the regional centers themselves in seeking the accreditation with USCIS, as well as what people I think of as the more common scenario where you're representing the actual investors. And we're going to talk about both of those. I think the EB-5 area is one that's, I think it's a little bit at first intimidating for some people because, you're dealing with the large amounts of capital that are being involved. And so let's take these things one at a time. Let's talk first about representing the investors. And as far as the criteria for becoming an EB-5 investor as a foreign national, what are those essential criteria? And what really makes the difference in someone choosing, well, yes, I want to use a regional center, I want to invest in a regional center versus I want to establish my own enterprise? What are the differences in terms of the profile of the individuals that you see making that choice?
Sure. Well, most investors that we work with tend to be those that don't have an alternative path through another green card process that might be less expensive versus making the previously $500,000 to now $800,000 investment or more when you add in other fees and costs associated with it. So most of those are individuals that simply are maybe sometimes waiting due to long visa quota lines, as well as some that simply don't want to go through some of the other traditional routes, such as employment-based immigration of working for an employer and then or trying to find an employer that's willing to sponsor them. Those are some of the basic profiles, which I think tends to sometimes be students, maybe other senior applicants that are simply looking to retire here. But you also will find, I think, a lot of entrepreneurs that simply don't wish to be working for a particular employer for many years before they can do what they would like in their field of business.
Mm-hmm. And as far as the difference between investing in a regional center versus investing, in an enterprise that they establish, what sorts of basis for making that decisions do people employ?
Well, it's a few. I'd say generally, if someone wants to be involved in the day-to-day operations of their business and making those business decisions, directing and controlling their investment in order to generate their profit themselves, they may want to do their own, establish their own business and be responsible for creating the jobs. Some will do that based on their own experience in that field, or others are simply entrepreneurial and willing to try different business enterprises and do that for themselves. Others that simply don't want to be involved in the day-to-day operations that heavily will look to a pooled investment project, which now has to be under the regional center program in order to pool their investment with other investors that are developing some type of project, whether it's a hotel or commercial piece of property, a restaurant, perhaps, or other commercial activities, usually pretty major.
Is it fair to say, would it be a fair characterization to say that most of the people who invest in the regional center programs are people who are more interested in the immigration aspect of it, like they want to move their family to the United States, and this is a way for them to do it where they didn't have another basis for immigration? Whereas people who come in as independent entrepreneurs oftentimes are actually looking to avail themselves of the U.S. market and maximize their business opportunity in the U.S. Do you think that's a fair characterization, or is that too general?
Oh no, that is absolutely true. And many of those investors will, we will always look towards another maybe temporary path that might allow them to be able to gain entry into the United States sooner. Some individuals might have treaties with their countries in the United States that would allow them to make a smaller investment, such as the E2, maybe L1s, or other types of potential visas, maybe national interest waivers, depending on what they're planning to do in the United States. But generally, most people are, I think, looking to exit their countries for different reasons or the other. Why else? Unless they're, some are perhaps maybe very entrepreneurial and have very big business here that they wish to deal with themselves and need to be here. But it is definitely that I think characterization that you're giving.
Mm-hmm. Okay, I want to mention for our attendees, if you have questions, please write your questions in the chat, and we will, or in the Q&A section, we'll be taking those at the end. What are the current investment limits for doing regional center versus your own enterprise?
Well, the limits are, the financial amounts are the same whether you're doing this on your own or you're with a regional center. It doesn't matter whether you're with a regional center or doing this on your own. The investment amount is determined based on the geographic location of where you're investing. Essentially, that means either it's an area with high unemployment, as well, it used to be determined by the state governor's office that appointed someone there to make those determinations of high unemployment areas, or small census tract areas. And now it's USCIS, which is one of the changes in the law, or it's a rural area where the population in a particular city or town that's outside of a metropolitan statistical area, I think it's MSA, that has less than 20,000 people there based on the latest census.
So it's not that.
Mm-hmm. Yeah. So it's not necessarily regional center or non-regional center. It's based on those factors.
And that's a change, right? Because previously, wasn't it 500K for the regional center investment and $1 million for the non-regional center? Isn't that how it was?
No, it was always that way.
Okay.
In the past, it was the state governor's offices that could determine whether or not a particular, say, census tract or city block, for example, was a high unemployment area based on the economic unemployment data they had. Regional centers or non-regional center investors were previously able to invest at $500,000 based on one of those two factors of being in a rural TEA or a high unemployment TEA, target employment area. Now it's essentially, it's just the way you determine whether an area is a TEA now is up to USCIS in terms of the high unemployment TEAs. There's also a third new, what we call reserved set aside visa category, subcategory of EB-5, and that's infrastructure projects that may also be able to, I believe, benefit at the lower amount. But those are very, we don't have a lot of guidance on, I think, exactly what will, when we'll see an infrastructure project. So otherwise, it's those two factors that determine whether or not now at the higher amount of 800,000, the lower amount of 800,000 or the higher amount of $1.05 million.
Understood. Now, do you see your client base coming from particular areas of the world, or is it all over the place?
It's all over, but we do know where the demand of investors are. These last few years, a lot of investors are coming from India, are coming from not as much from China, but in the past there's been high demand there, as well as from Vietnam, those countries. I suppose some of the BRIC countries have definitely had a lot of investors, but not enough to use up all of the annual quotas. So Brazil, Russia, and I just mentioned India and China.
Let's
have
talk
been
a
some
little.
very, very popular countries.
Let's talk a little bit about the history and sort of the recent changes. So how did the EB-5 program, when did it come about, and what are some of the recent changes? I know it's, it has been stalled. There was a period where it was recently the regional center portion of it was stalled for a while, which needed reauthorization. So let's delve a little bit into the history and the politics around it.
Sure. So the EB-5 program, once known or referred to as the basic EB-5 program, was created in 1990 when it was passed into law as a permanent program by the U.S. Congress and signed into law by the president then. The program was then amended 2 years later when the EB-5 Regional Center Pilot Program was created to allow projects to create jobs through reasonable indirect methodologies. So the Regional Center Program was created a couple years after. It was a pilot program and wasn't really, I think, very actively used for some time until maybe in some of the late 90s, we started to see some cases that were emerging in a lot of other visas. Some more visas were being used, but not quite a lot, really. And it really was in the year 2007, 2008, when the financial crisis of the Great Recession occurred here, that the commercial marketplace realized that EB-5 could be a source of capital for a lot of businesses. And the economic crisis led to I guess, some of the rebirth of the EB-5 program, the use of the EB-5 Regional Center Program, which eventually had the name Pilot taken out because they've always had to renew the pilot program every year or 2 years, typically tied around the fiscal calendar when the budget needs to be passed every year. So it was over the last, I'd say probably, I don't know, was it 5 or 6 years, since 2015, 7 years, that the EB-5 regional center industry has been contending with potential changes to the program, threats of deauthorizing the program, lapse of the program, so-called lapses that were going to maybe shut down the regional center program. Those laws never came to pass, but it did drive up a lot of demand of investors filing during that time. because those threats were pretty real that they were going to increase the investment amount.
Mm-hmm.
It was finally in the summer of 2021 when two U.S. senators, Senators Grassley and Leahy, basically put a deal on the table that said either you're going to take this or we're going to let the regional center program become deauthorized. And it was in June of 2021 when the regional center program in fact did get deauthorized. And actually I take it back, it was the summer of 2020 when they made this deal and basically said we're going to give you 6 months, and then it 6 months past the next expiration or so, and it came out around June. Pretty much. So it was also coincidentally, or not coincidentally, but there was a major litigation case filed by a regional center in the summer of 2021 that led to the rollback of regulations that did come out that affected the EB-5 program in general, and was implemented in 2020 that increased the EB-5 minimum investment amount from $500,000 to $900,000. However, those regulations were implemented towards in the beginning of the Trump administration in 2020, and the regulations were never properly implemented. So in the summer of 2021, a federal court in this litigation matter called Bering Regional Center versus, I think it was USCIS, invalidated the regulations. And then we had basically 1 week of a valid regional center program that was able to have investors file at a $500,000 amount. But the regional center program did become deauthorized, at least in some sense, and was stalled, at least by USCIS, I believe impermissibly at that point. And it was until March of this year, of 2022, specifically March 15th, 2022, when the EB-5 Reform and Integrity Act was passed that revived the EB-5 Regional Center again for a number of years now, and also increased the minimum investment amount back, which was at $500,000 for some time again, and now it's at $800,000, with the higher investment amount being $1.05 million.
Do you see people who are coming to you, the investors themselves, making a decision between the U.S. program and maybe some other programs around the world? Certainly, there are a number of countries that have these investor visa or immigrant investor programs. I wonder if you have a sense of how we stack up competitively in terms of what we ask of people in order to immigrate here through this route.
I think those other programs are definitely in demand. They are being used, whether it's in Portugal or some of the other citizenship by investment programs. I don't really know if those are really overtaking the U.S. at all. I don't think they are. There's still a very large demand to immigrate here. There's some programs like in Grenada that allow citizenship to be obtained there, and a lot of investors are doing that so that they can then utilize the E2 visa program to invest here. There's other countries that offer a CBI like that. Turkey has, as well as I think in the past it was Moldova, but I think they don't have that program anymore. They do have an E2 treaty with the United States. And I think there might be some new countries soon that will be announced that are going to have some, I think, residence programs that might help. But it's all over. There are various other countries that do CBI either for economic citizenship or residence programs. So, everyone, sometimes it seems these days certain people want to have multiple passports.
Mm-hmm. Okay, let's talk a little bit about the practical details of practicing in this area. I mean, if you're an immigration practitioner, maybe you're an experienced immigration practitioner and you want to go into this specific niche. I mean, what do you really need to think about in terms of the infrastructure that you need to have set up in your office, in terms of your insurance, in terms of some of the other services and professionals that you're going to need to call upon for handling these types of cases?
Well, our practice has been, we're really a paperless type of practice these days. We're very digital, thanks to technology like DocketWise that lets us really streamline a lot of things. I mean, it really is it's a huge factor, but we use a lot of cloud-based software that allows us to stay paperless. Many of our clients don't have the ability to ship the thousands of pages, 1,000 pages of their personal financial records to us. So you do need to have good technology behind you to be able to work, I think, in immigration law today, and you have to make some small investments there. Other than that, you certainly need to do a lot of research, I think, if you're going to get involved in the EB-5 program. And there's a lot of resources, a lot of conferences that you'll have every year that you can go and attend and try to learn about how the EB-5 program works. There's a lot of different books out there in the marketplace, a lot of resources, a lot of really good blogs and companies out there, even other law firms that you can read about, read on their websites to learn quite a bit about. And the more you get involved, you start to, learn about who are the some of the top information, companies out there that you might be able to learn about EB-5. You do need to have, in my opinion, a insurance liability malpractice insurance plan for your practice if you're going to work in this area. I think anyone that practices law should have that. Certainly, if you're not really sure how to work in this, to prepare an EB-5 matter, you definitely would want to co-counsel, or at least consider, sometimes referring the case out is maybe the consideration, but it really depends. Some other attorneys, just don't really want to touch it, and just like I don't maybe want to touch asylum matters, I'll refer those cases out, or immigration matters today. It's not always in my wheelhouse of the cases that I'm handling regularly, but it's I think if someone's involved in different investment immigration and is used to tracing funds and millions of dollars, then you can maybe consider it. But you have to be very careful with EB-5. You have to constantly stay up to date with the changes to the program, changes to not just the law but the policy. It's a very busy program with a lot of policy interpretations that are always changing.
So let's walk through a scenario. So I'm a potential investor. I've contacted Michael Harris Law, and what happens next? I mean, you've described what the requirements are. We've determined that I meet the requirements, and what actually happens next?
Well, we see what the investor is interested in doing once they understand that, or once we've ruled out that there's no other option for them to become a resident or here, assuming they're already here temporarily. We then look to evaluating their sources of income to see if we can trace the income that they're going to, or the funds that they're going to utilize in their EB-5 investment. If we can document that, then we have a bona fide case that we could prepare and file for them. They'll then have to decide where they want to invest. And that, if it's their own business that they're developing themselves, then they'll go and do that. We'll bring in a business plan writer or refer them to a business plan writer. We don't hire one in-house or anything, but we would recommend a few different business plan writers for them to interview and see whether or not they wish to develop their business with that person, with that company. If they're interested in a regional center project, what we generally feel comfortable doing is sometimes there are some very good broker dealers out there that can help them to find a project. It's not too hard to also discover there are a few, probably a very small handful of regional centers that have been around for quite some time. A few are some of the oldest out there that have had some public results that they've at least shared out there about their ability to repay capital, about the success of their projects. But those investors need to realize that their immigration attorneys are not there to recommend, shouldn't be recommending projects or directing them to a particular investment opportunity. unless they're a registered financial advisor. I think most, all of my clients know that that we don't recommend projects to them or investments to them, and asking me to make a qualification for them on that would be like asking your dentist about, whether you need to have a heart surgery.
Let's drill down a little deeper into this. So you have an independent business plan writer typically that you refer them to, and then what sort of review of the business plan do you do as the immigration attorney to make sure that it would be satisfactory? I mean, how deep, you don't get involved in writing the details of the business plan,
Right.
obviously, but what
Right.
are you looking for to make sure that you can use it in the case?
Well, there are going to be assumptions in the business plan that are going to be made in there, financial assumptions that will say they're going to have this much revenue, or how are they justifying in the business plan that they're going to have the success that they're claiming they will have? Have they what business documentation or evidence do they have to justify the business plan as being a real business plan, a real business that's going to occur? So there's other documentation in support of a business plan that will be utilized, in addition to financial information which investors provide or other analysts might provide to them. If they're developing a shopping mall, for example, have they acquired the land? Have they leased the land? If it's a store, have they leased the land for the store or the space for the store? Do they have construction drawings already? How much documentation do they have to show that this will be a real operating business? And then will the business have enough jobs that are forecasted in the business plan if they're already not, if they already haven't commenced the business, started operations and created jobs? Then the business plan is critical under matter of Hode, a seminal immigration case, to show that they will be able to create enough jobs within 2.5 years of adjudication of the I-526 petition that is filed. If it's a direct investor, regional center investors now have a new form called the I-526E that gets filed when they invest in a regional center.
What are the job creation requirements?
For a direct investor that is doing, it's 10 jobs, 10 new jobs that are created by the company that they the new commercial enterprise that they are investing in. And there's some little differences there depending on, they could have multiple companies underneath their primary company that are wholly owned by that if they're diversifying their jobs across, but it's 10 new jobs that would be for full-time workers created within should be started to be created within 2.5 years of the adjudication of the I-526.
And then if you're investing in a regional center, does the issue of job creation not even enter the equation because they've already been certified by USCIS, so you're not even concerned about that? Or is USCIS watching those metrics as part of its recertification?
Yeah, so a regional center is just think of it as a license that provides a company the ability to operate. The regional center then has to comply with the legal requirements of the program, which says that in the past, those projects had to have business plans that did not need to be pre-approved by the government, but you could request pre-approval, which was called an exemplar I-526 petition. And the projects had reasonable economic job creation methodologies, utilizing, say, indirect job creation to show how they would have at least 10 jobs per investor, which could be indirect jobs. So sometimes those jobs may have been created by the time the investor went into their project in some situations, and that still might be the case today. But nowadays, each project that an investor invests in under the Regional Center Program will need to also have filed what's called an I-956F, which is a essentially very similar to the exemplar process that we were voluntarily needing to do, would suggest to do to our clients on the, for each of their projects that were sponsored by the Regional Center program. So any project that a regional center investor is investing in must have an I-956F receipt notice issued to them in order to, or show that they've done the filing. And there's just been a settlement that occurred regarding another litigation matter that sued the USCIS. Again, it was the Bering Regional Center that did another lawsuit that was basically allowed the regional centers to resume operations, because after the law was passed in March, the USCIS came out with public notice saying that the regional centers needed to reapply all over again. So if a regional center was in existence prior to March 15th of 2022, they don't need to designate themselves as a new regional center under the settlement, but they do need to file an I-956F application to have their business plan reviewed by USCIS. Once they have that receipt, even though the project has not been approved at that point, the investors can file that business plan, though the requirements have changed under the RIA law that was passed in March. So regional center investors must be able to show that their investment will lead to the creation of 10 jobs, but all of those jobs can no longer just be indirect jobs. One of those jobs must be direct jobs that are being created there, whether that's in the NCE that they've invested in or part of the JCE of the job creating enterprise that's underneath, that's receiving the capital, for example.
Are those all full-time, or can they be a mix of full-time and part-time, or?
Well, it has to be full-time.
Full-time,
means typically it's 35 hours a week or more. There has, been a concept called job sharing, where two workers mutually agree to share one job and the benefits that come with it as a full-time worker. That's a possibility there, but typically it's a full-time job with one person.
In terms of tracing the source of funds, I mean, what are you really looking at beyond, obviously, making sure that they came from a lawful source? And how do you actually go about that? I mean, what sort of documentation do you need, and what are some of the pitfalls?
Well, it depends really on the investor. Everyone has a different story about how they've earned their funds, what type of work they've done. If it's employment-based income, we might look to how they saved that money over the years. Maybe they spun that money off into buying some real estate or a home and sold the home. So we need, we'll need transactional records, employment verification records, tax returns over a number of years. And then we have to look to when that money was initially invested, maybe by them. So how far back in time do we need to go? We'll have to evaluate each investor on a case-by-case scenario. Maybe it's not as complicated as that. Maybe it's simply that they sold one property at 1,000% increase, for example. They bought it for a small amount of money, which is recently documented, and then they sold it for a higher amount of money, and they were, able to profit off of that. Or maybe, they borrowed the money from a bank, and the bank loaned them the money, but then we'll have to show how did they acquire the property that was secured by the bank. It could be, maybe the government paid them a lottery or a civil settlement or something, winnings. So that could be a really easy case, I suppose. If you win one of the a major lottery, and then you get a payout there. But usually that's not the situation. Our clients tend to have very complex financial histories that might require us to go back many, many years to look at it, to document it and how they got the money out of their country. So each country's got different requirements, different of record keeping, of documentation that they might have available. And how they even transfer the money out of the country. So some investors from certain Asian countries, for example, have financial limitations on how much money they can send out of the country every year, anywhere from $5,000 to $50,000 to $250,000 every year that they can send out. So some investors will utilize different methods to some legal methods to get their money out of the country, giving the money to another friend to exchange it. And that just opens up more questions, unfortunately. But we work with clients like that, and we'll document how they exchange the money if that's the case. If we're not able to demonstrate that the money originated from a lawful source, and we have to, the burden, the standard of proof that the government uses for these cases is supposed to use is the preponderance of the evidence standard, which we use in other cases, that it's more likely than not that the funds were lawfully earned. We don't have to show clear and convincing evidence, but the government sometimes makes us feel like we're being held to that standard. So it really depends. As long as we can show how the money was earned lawfully, more likely than not, then we should have a good opportunity. But again, it all depends.
Now, is that sort of tracing something that you personally do, or do you ever need to hire a forensic accountant or a private investigator or anything of that nature?
You sometimes might need an accountant in the foreign country that's able to work through the documentation for you, especially if it's in a foreign language that you're not able to read. But it really, again, it depends. Some clients will say, okay, I know how to get this. I have my tax records, my bank records. We give them a list of what's required. And then if they need more support, then yeah, we will recommend that they work with their accountant overseas to help them trace this maybe for them. It really depends. I've had clients with 50 different properties and in certain Asian countries, and then they have to it's not easy to advise them to go through all of that. They will need to have a foreign lawyer or a foreign accountant, a licensed accountant, be able to go through that with them. But we do end up receiving that sometimes, whatever, it's 100 or several hundred documents from a particular client, and having to go through that and make sense of it and submit that to the government.
Okay. And if they're investing in a regional center, obviously, as you said, you can't advise them to choose one project or another, but how do they learn about these projects? I mean, do they do that outside of sort of their relationship with you as the attorney, or can you point them to some of the regional centers and then they simply need to choose?
I think you have to be careful. Since we're not investment advisors,
Right.
There are some regional centers that are very well known that they might come up. I might be able to tell them about some of those, but what I prefer to do more and more of these days, given the new requirements by the Reform and Integrity Act, is to recommend that they speak with a licensed broker dealer registered with FINRA that can allow them to review particular different projects. Those advisors, those broker dealers representatives are licensed to be able to recommend the investment, typically at no upfront cost to the investor, though the investor's administrative fees that they pay to the regional center will be received by the broker dealer as a commission of some sort. But even the broker dealer might be able to help negotiate with that and help those investors. So there's not a lot of broker dealers, but there are some out there that I work with closely that can help make those independent decisions to what to recommend or not for the investor. Sometimes it's common sense. Obviously, if an investor comes to you and says, "Hey, I'm about to invest with a guy named Madoff," or something like that, and you've heard something, this guy's under investigation or there's problems, you might say something. So there's certain things that you have to be aware of, but other than that, it's my role is to prepare their documentation, and we do get involved in reviewing some aspects of the project itself. It crosses into immigration law once we start reviewing the capital stacks of the projects to see how their financing is going to work out, whether they've secured loans or not, whether they whether they've reasonably estimated the revenues or the operations expenses. All of that will be needed to be documented with the project. That the project will file this other application with USCIS. So projects will have a variety of documentation to justify that their project really costs what it is, or third-party construction review, appraisals of the property, feasibility studies of the projects, other analysis, market reports regarding the average room cost of a hotel, for example. So some of those things we do have to help our clients, to investors, to understand whether or not it's reasonable or not for them to invest there. If a project says that they're going to create most of their jobs from revenues, and those revenues haven't occurred, then it's my responsibility to let an investor know before hopefully they invest, that that the project is relying on revenues, that if they don't occur, the jobs won't be created based on the indirect jobs, at least, that they're using a lot of those from revenues.
Do you see these regional centers, are they sort of all over the place in terms of the industries that they're operating in? And are there any general trends as far as the number of investors that they tend to involve in a particular project and the pooled capital amounts that are involved?
Yeah, most of the projects have always tended to be commercial real estate or residential real estate development projects, mixed use projects. That's generally been some of the trends of the types of projects that EB-5 has worked for. However, during the deauthorization period of the regional center program from June of 2021 until March of this year, we saw, because we weren't able to use indirect job creation, we saw a lot of projects come out there that were heavily full-time job needed businesses, like factories, factory businesses to manufacture different types of goods and products. A lot of restaurants were out there as a result. And restaurants, I think, are sometimes still popular amongst some investors, though they won't be able to pool their investment funds with those unless they're with the regional center program anymore. But restaurants have still been popular for some. But I think most of what you see out there tend to be real estate development projects, with some others that are sometimes coming in there. You'll find some unique different projects out there in the market, maybe mining, once in a while some infrastructure projects that are available there. But most of what you'll see are real estate projects.
And at what stage does the investor actually invest in the regional center? I mean, is that sort of, do you prepare once you've finished your review and tracing of the source of the income and otherwise finish evaluating the case, and you have and I imagine, well, you don't need the business plan with the regional center, but at what point do they actually invest? I mean, while you're preparing the petition, and how does that actually occur? Do they, does the money go into an escrow account first, and then it's forwarded to the regional center? What are the mechanics there?
Yeah, that's a great question. We typically will advise our clients to wait for our source of funds review to be done before they transfer their funds, to make sure that we have the right path of funds that we're able to document. Some investors might have more than one path of funds that they could choose. They might have $1 million that they earn from one stream of income that's not part of the other stream, a different business perhaps. So we will go over that with them. But there is no prohibition that they invest before they file all of the money. But they usually will do so at the time of filing. The law says you have to have invested the capital or be in the process of investing. So all of our clients do contribute the full capital investment required, the minimum investment amount at the time of filing, previously $500,000, now $800,000. So that is required at the time of filing. Some might try to invest a smaller amount to show that they're in the process of finishing their investment. That, I think, is something we've seen more and more happen over the last couple of years. But once the investor transfers their funds over to, say, a regional center, Uh, Most of the the really good regional centers will not release that capital until one, they have confirmation of the I-526 filing. There's really not many other conditions that projects are utilizing these days. They do want access to that capital sooner. In the past, we used to see, because of shorter processing times, we saw escrow used. Escrow is not really used other than a third-party lender, loan administrator that might be receiving the capital and only releasing the capital once certain checks have passed from the receipt of the case to the by the government there. So they won't release the funds sometimes that quickly. So you want to look to a regional center probably that is at least the investors' funds are going to a bank account for a bank that is that has been long steeped in the EB-5 program, and probably also has another tech company actually involved with it. Used to be called NES Financial. Now they have a new name called JTC Financial that is probably the largest EB-5 administrator of funds there. So to try to at least provide some more security for the investors' funds before they get released into a project.
And then post-filing, what are some of the most common bases for RFEs that you've seen?
Another good question. It's either going to be obviously the investor sources of funds or the project. We tend to see more RFEs sometimes on the project side, but when we do see them on the investor side, it might be simply could be something small to something more serious of being able to further trace the origin of the funds. Project questions can vary. Really, has the project is it a meaningful project that will be established? And the government is taking more steps to confirm that these projects are real at the time of adjudication. And if it's a couple of years or so later and the project has stalled, they'll want proof of that the project is actually proceeding according to the business plan.
And what sorts of rates of return are people getting? So, and at the end of this process, so how many years is it after their initial investment that they're actually getting the return of their original capital? And are they getting what rate of return are they getting on top of that? I mean, generally speaking, have you seen with the regional centers? Let's take that question.
Yeah, I mean, well, we don't really advise our clients over, what amount of interest they might make, because that might be investment advice. But most of the projects that people have invested in are loan-based projects, so their money is usually loaned to the project for up to 5 years. And then if the investor has not in the past, if the investor hasn't filed their I-829 to remove the conditions on their residence, they've had to redeploy their funds. The project would have to redeploy those funds to another investment activity. That the rules of that could probably be discussed over a few more hours. But redeployment is a serious issue of what the projects might need to do to comply. There's also been some changes under the law that say that essentially the law now says that the investors need to have been invested, have their investment there for at least 2 years. And then whether or not they redeploy or have to sustain their capital is at least if you don't sustain your capital under the law for the full 2 years of your conditional residence, it may no longer be grounds to terminate your residence. But this is still a developing issue. As far as the interest rates, I've seen from what I know projects are doing, it's anywhere from very small fractional amounts to 0.5% to some that are doing 3% on loan-based projects. Some will go higher, I think, and those are maybe riskier. The higher the interest, I think, tends to show that the investment project might be riskier, but each thing is different.
Got it.
Equity investors whose funds are being made as invested into another company might, maybe they yield higher returns. But a lot of investors are receiving a very low return, interest, at least offered interest rates on their investments. Generally at a, I'd say probably around 1% is what I've heard.
All right, so it goes back to that issue of it being the primary purpose is really the immigration aspect of it, and it's a safe place to make the investment.
Yes, yeah. I mean, there has to be a risk of loss. The government says there also has to be a chance of gain. So we'll see what happens with that if the interest that's being offered is too low. But usually, you'll see between 1% to 3%. Hopefully they get their principal back and they make some money on top of it in order to. And the purpose of the program really is job creation, in my view. And if those jobs have been created and your money stayed at risk, then you've complied.
So, and the typical scenario being, so they're making this investment at the time of filing, and that those funds are staying committed through the adjudication process, and then they're granted conditional residence, and 2 years later they have to file for removal of conditions, and the funds are staying committed typically until the granting of the removal of conditions.
No, over time now, the government's policy has changed that says that once your I-829 is filed, you no longer need to have your full investment amount in the project. So projects have been releasing the capital back to the investors, allowing them to exit once their I-829 is filed.
Got it.
That's been the policy that the government has had for a while now, and has led to that redeployment policy for if you haven't filed your 829 yet, you needed to redeploy your funds. However, there's, as I mentioned, the RIA has changed some of those legal requirements under the statute now. So whether or not someone has to redeploy during their conditional residence period might be, something you want to discuss with your immigration lawyer, really, to understand whether or not you should redeploy. I was just talking about this today with someone about considering do I withdraw my money now or do I wait until my 829 is filed. Most projects are probably going to say wait until your 829 is filed, and be wise to probably not allow the investor to get out until then. But we'll have to see what the market does.
Understood. And I know this one thing that popped into my mind, and I guess I'm pretty sure it's not a common scenario, but suppose someone makes the decision to go this route, they invest in the regional center, and then at some point they change their mind, they want to withdraw their I-526. Do these projects have limitations as far as backing out, or what happens?
The contract controls the contract that they signed of the partnership of the company that they've invested in, whether it's an LLC or an LP or whichever form, will determine when they can exit. They might be in there for a loan, a period of time under a loan, or unless it might be an equity investment, and then eventually they, when there's cash flow, they're able to exit. It really depends on the project and the regional center.
Okay. All right, let's talk a little bit in the remaining time we have about representing the regional centers, and what's sort of involved as an immigration attorney in representing regional centers, and what do you consider to be your scope of services, and how is this going to differ from from representing the investors? I mean, they're going to retain you for what sort of process, and what other considerations do you have to think of?
Well, when you represent a regional center, it's a multidisciplinary practice involving securities lawyers, corporate lawyers, lawyers in the different respective fields, real estate law, for example, if that's the area there, that the projects that are being sponsored by the regional center are involved with. So because the projects that are sponsored by regional centers need to comply with immigration law, and now it's in the law now as well, that they have to comply with U.S. securities law. So it's a very, when you represent a regional center as an immigration lawyer today, you may be involved in advising them on what requirements they might need, what steps they might need to take, as well as what other parties they might need to get involved in the affairs of the regional center. Some immigration lawyers are in-house with regional centers. Others are not, maybe just simply preparing the different project filings that need to be submitted by investors, preparing what are called templates. whenever an investor invests in a regional center, the regional center should provide the immigration attorney of that investor a template of materials that hopefully is pretty clear in understanding how to put it together, and not just simply something that allows the investor's attorney to re-describe the whole project in their own words. So the best projects out there will have really good templates that make your life easier when you're simply plugging in the investor sources of funds into those materials. So as an immigration attorney, you could be preparing those templates. You might also be involved in the other compliance issues for the regional center, such as annual reports. But again, we're working with other counselors, business plan writers, economists that are involved in making sure that these regional centers are operating correctly. And even broker dealers now are trending to be very involved with regional centers because of the new laws requirements that that every regional center that is out there, unless they have an independent audited financial statements every year, they need something called a fund administrator that is, I think, is really has a lot of securities laws compliance requirements that they administer certain things properly with the project and according to this new law that they'll have to submit to annually. And there's a lot more penalties if a regional center doesn't do the right thing, and they could get disbarred or terminated for not complying. So it's a pretty complicated role for an immigration lawyer getting involved, but usually you'll start at some point. Maybe some will start with investors or other types of investment immigration work before they jump into it.
Got it. Well, we're at the end of the hour. We could go on and on. We could talk for several hours on this topic, but Michael, this has been extremely informative, and I'm sure that our audience got a lot out of it. We are going to be posting the video to today's session, and Michael, hope that we can have you back at some point to go into some of these areas in more depth. And as other legislation comes into play, we'll certainly keep you in mind to come back and talk to us again. Yeah, sure. It'd be my pleasure. And I think that as an immigration lawyer, someone that's involved with I'm involved with a lot of technology, like provide, as a subscriber of your services. The technology, I think, is you have to be with a company that is evolving with the practice, and that's why we work with DocketWise, because of its ability to help us leverage technology to make our practice easier. But there's so many different things that we have to track these days in this program. So happy to join again, and thank you. Excellent, and thank you very much, and thanks to our audience. Have a good day all.